Good morning, ladies and gentlemen. Welcome on board of today's Theiss webinar. My name is Peter Oberlechner. I'm a partner in the real estate team of Theiss sitting in Vienna. Today I have a whole panel of renowned legal experts from various of our offices, all experts in real estate with me. Just to briefly introduce whom we have here, this is Ms. Radka Nenickova. She is heading our real estate team in the Czech Republic. We then have Mr. Zoltan Bodog, who is a key figure in our Hungarian real estate team. And we have Bruno Stefanik, who is spearheading the Theiss real estate practice in Slovakia. Today's topic is again, and some of you may have already seen some of our previous webinars in this respect, the change of use of real estate, the repurposing of real estate under various legal systems, which is clearly today the Czech Republic, Slovakia, and Hungary. Now, maybe to again give you kind of the helicopter view of this topic. It was in part the COVID crisis that stimulated developments that led to shifts on development on the real estate markets that were leading to demand, I would say, changes of demand patterns for real estate. Clearly, the COVID crisis had not contributed to the benefit of brick and mortar retail because people were buying online. But this has been a trend that has been going on anyhow. The COVID crisis has clearly also hugely affected the hotels industry and hotels business because travel was and still is so restricted. Now the question is in how far these are changes that will be lasting. Logistics is very high in demand, and also residential is booming in at least all the major cities that we have in Europe and elsewhere. Clearly, the question is which changes will kind of go back to normal levels again after we've overcome the COVID crisis. In other aspects, the question is whether the changes that we currently see may be of a lasting nature and are just signs on the wall for developments in real estate that have slowly been going on anyhow, but that have been accelerated by the COVID crisis. All of this raises the question in how far it is interesting to consider to change the use of existing real estate, i.e. to repurpose existing real estate. There are steps that may be easier to convert a hotel into residential, into maybe serviced apartments is not that difficult. This may be a bit more of a challenging exercise in terms of a vacant shopping mall, where the question is how to use the mall in future. What we within Theiss have been doing is explore the legal aspects of this and to find out how easy or difficult it is under given legal systems to repurpose existing real estate. Now, before we dive into the middle of the topic, out of interest as regards today's audience, we prepared just two questions. To ask you what your personal view is, where you see for which property types you would see the greatest need to find new, different, or additional uses in the future. We've categorized this into the main categories of retail, hotel, office, logistics, and residential. Now you're invited to answer this in the chat function that you see on your screen. Just click on the answer that you would be preferring. Multiple answers are possible. Again, the question, for which property types would you personally see the greatest need to find new, different, or additional uses in the future? Give you a bit of time to click on the answer. Monica, yeah, thank you. We've already have a result of this little poll. The biggest need is obviously seen for retail, followed by hotel and office. Not surprisingly, for logistic, no need for change is seen, and a little bit, I would say, there is also the need for repurposing in the field of residential. The other question that would be of interest for us to ask you as today's audience would be whether you, your company, is currently actually at the moment involved in such a project, i.e. into a repurposing project that your company, you yourself, keeps you busy with, keeps you busy at the moment. Is your company currently actively dealing with property conversion, change of use issues? Here, clearly the answer is either a yes or a no. Well, this doesn't seem to be so much of a pressing issue for today's audience. There is little involvement, active involvement into repurposing for you, as it seems. Well, that may change in future, of course, depending on how long the current situation is going on, depending on how future developments will work out. Now, to start now with our kind of little legal journey through the countries that we have present today, starting off with the Czech Republic, Radka, if I may ask you, how difficult or how easy is it to repurpose property in the Czech Republic, and what's the legal framework for this?
Yes, so generally it's not really very difficult. At least in the written law, it seems to be very easy because generally, so I will go to my slides to demonstrate it. Generally, those issues are regulated by the Building Act, which is the essential legal document, legal regulation within this area of law, where you generally find answers to all questions you may have in this respect. Generally, you would need only a notification to the building office that you are changing the use, because the owner of the property is not entitled to use any property freely, and should always follow the purpose of the use, which was determined by the occupancy permit, occupancy approval, or if none of them is necessary, in the building permit, for example, itself. However, what is very important whenever you intend to change the use, you definitely have to double check zoning documentation, because any and all buildings should be used in compliance with zoning plan, which is fully in discretion of the local authority. So this is a very important thing to be checked. And we also have to warn the audience that if the building would be used contrary to the defined or approved purpose, there may be a fine which may be imposed. So therefore, it's really important to double check that all documentation is in compliance with the law. So generally, to change the use may not be very difficult, depending, of course, of the character of the change. So it will be definitely much easier if you change, for example, hotel to residential than all other changes which you named. The next issue, which I think is connected with this, is to double check always what kind of use you are really going to implement, and you need to consider the exact scope of the change, where again the building law, building act can provide you with a nice guidelines, what you have to do and what you have to follow, not to be in breach, of course, and to be able to reach the aim which you have at the beginning. If we should answer whether the rules to change are clear or not, and I will switch to another. I mean, generally, yes, the rules are quite clear. However, there is still provided a discretion for the building authority to consider some things differently. So generally, it depends on the municipality where your property in question is located, because also this municipality can involve hugely the whole process of the change. Besides the Building Act, there is also a decree regulating detailed regulation of land planning, which should be followed. And what is necessary to say, and I'm more than sure that our audience is aware of that, although the law is generally national-wide applicable in certain regions, in the meaning of the cities currently, there may be different regulation in place which also have to be followed. And this is namely question of the capital city of Prague, which has its own construction regulations which have to be followed, which are declining a little bit from the general norms applicable to the whole country. And as you may be aware, currently the Czech Parliament is actually discussing a new Building Act, which should implement a possibility for other major cities of our country, being Ostrava and Brno, to adapt their own local regulations, which then, of course, will worse the situation for any developer, because any developer would have to check not only the national law, but also would have to check the local norms just to see whether its intended change is in compliance, for example, with technical requirements which may be imposed on the certain type of the buildings. The next issue which I may discuss, I actually touched what is included in this slide. So the next issue I may touch is how the change is regulated by the process. So the Building Act and the decree stipulates the application which needs to be applied to the building authority, which has actually certain compulsory annexes which have to be attached. And depending on the type of the intended change, you are simply collecting all those annexes. So definitely what differs are annexes which have to be supplemented as well. Sometimes if you are changing the use of the building, of course, there are some construction changes which are required as well. And this is another topic which needs to be considered very well, because, for example, if you are changing hotel to a residential project, most likely you may not need to execute any construction changes. However, if you would intend to change or to turn retail project, for example, in residential, there will be definitely some construction changes. So you have to bear in mind that generally you may need a construction permit, which of course will make the whole procedure much more difficult because with the construction permit change, you are in the standard administrative proceedings. And as you may know, the Czech Republic is not really the best off in administrative proceeding relating to constructions. So there you may really face a huge time delay problems. However, not just to scare you so much, there are definitely construction changes which do not need construction or building permit, and they will be allowed only based on either notification, or you are even allowed to procure with some construction works without any notification, without any permit. So in each particular case, you definitely need to consider any particular specifics of the given project.
Radka, thank you so much. If I may just interject one question. You mentioned, of course, the zoning as being a prerequisite for all else, that somebody has to obey, developer, investor, whatever, for permit issues. Do individuals have an influence over the zoning? Could let's say, for a particularly important project, somebody apply for a change of the zoning? Do individuals have legal standing in proceedings that would lead to a change of zoning?
Yeah, I mean, generally the Building Act allows everyone to propose the change of zoning, even individuals or legal entities who at least have a property in the given, let's say, municipality or cadastral area. However, there is not entitlement to such change. So yes, you may approach the relevant municipality, but it is not guaranteed that they will actually grant you with the change. So it's definitely, but of course, like each investor may do it as well. And if it is like an investor, it has much bigger chance that his at least proposal would be paid attention to. But it's definitely better, for example, to pre-discuss it with members of the council, just to put them in head the idea. And it definitely depends on the type of project for which you will want to request the change of the zoning, because if it's something what is in favor, for example, in the given area of the given municipality, then you may be sure that they will at least pay attention to such proposal.
Thank you. Now, in view of the fact that we have 3 countries to cover in this 1 hour, basically we are a bit pressed with our schedule. Are there other important points, Radka, that you would like to stress for the topic of repurposing and the Czech Republic specifically? Is there anything where you see kind of the need for legal changes, legal loopholes, legal needs for improvement? Is there anything that you would want to give somebody as a guidance who is considering repurposing?
Yeah, actually, as I said, in the Czech Republic, we are really struggling with the length of the administrative proceedings, especially in construction area, which hopefully may be solved by a new bill, which is currently discussed in the parliament. Probably no surprise for everyone that there is several months delay already with adopting this law. So the original plan that the full new law will be effective from 2023, it's somehow probably not manageable, but still this new law may bring some changes depending on of course, comments and changes which would be made within the parliament. So this is definitely one light which everyone has. On the other hand, to go through change of the use may really speed up the whole process, because even the municipalities, the local authorities, of course, should have some interest in use of the buildings, especially if the buildings are, for example, empty and they are not currently used. Unfortunately, the market currently is a little bit quiet because everyone is somehow waiting for what will come in next days. So let's see whether there will be on the market many hotels, for example, or shopping centers, which is not the situation yet. So we will see, and to repurpose or recategorize them would be definitely one of the possibilities how to meet even like social requirements and how to enable better use of the land and simply properties within the Czech Republic.
Yeah, I think that's a valid point, probably also for other countries. Thank you, Radka. Now, switching to and moving to the Slovak Republic, Bruno, just linking to what Radka had said, how Radka had described the process, the legal framework with respect of the Czech Republic, how would you describe things applicable in the Slovak Republic? What are the differences? What are the specifics of the Slovak legal system in this respect?
Thank you, Peter. So I think listening to Radka and obviously talking to Radka before, I think the system and the way it works in Slovakia is quite similar to the way it works in Czech Republic with a few deviations. What is similar is that we do have a framework for change of purpose of property in place. But the framework is quite brief. The problem in Slovakia is that we have a fairly antiquated construction code, an old piece of legislation from the 1970s, which reflected obviously a completely different economic reality. And it has been amended over years, but fundamentally it's still a 1970s code that was designed for a different society. And it doesn't reflect the market needs, obviously. And so it really confines the framework for change of purpose of a property to pretty much a single provision of the code, which then directs the reader to the general provisions of construction permit and use permit. So another similar point with Czech Republic is that our law also specifically defines the use of a property. So the use of a property is defined by a combination of the construction permit and a use permit, and it tends to be quite specific. So sometimes you see your property being permitted for non-residential purposes, typically for smaller premises such as shops or offices. But with a modern development in the past, say 15, 20 years, you would typically see a fairly specific purpose of your property in the use permit, such as retail or offices, etc. And if the investor wants to repurpose the property, then the use permit needs to be changed. And then there's the procedure in place, the framework, which allows the investor to apply for such change and to comply with the requirements of the law, which, as I already said, are rather brief. So if we take a hypothetical plan by investor to repurpose their property, they have to look at the use that's permitted by the use permit, and then they have to assess what other use they want to propose. They need to apply for an approval of change of use to the relevant construction authority, which in Slovakia are municipalities, so towns where the property is located. And then pretty much two routes are possible. If no construction alterations are required for the change, then it would be an issuance on approval of change of use, which is procedure very similar to a use permit or commissioning, if you will. Or if construction works are required to make the change, then there are again two different routes. Either if the construction works are fairly minor, there's an option to just notify some changes to the construction authority, and the construction authority has a brief time window to confirm those changes and they can be executed. Or if the works are more substantial, so for instance, like Radka said, maybe if you want to convert an office to retail, then maybe you just need to do some internal fit outs, and you don't have to take the entire construction permit route. But if you want to convert an office or a retail premises to a residential premises, then for sure you will have to comply. You have to make such construction alterations that will require a construction permit. So you have to take the full route, which pretty much brings the investor to a application for construction permit, construction, and then subsequent application for use permit, which again would be under the bigger heading of an approval of change of use. So I mean, this is the basic legal framework, but then obviously the devil is in the detail, and there's other things that factor into the project, and those are obviously zoning plan, because at every stage of your process, the construction authority, by operation of law, they will have to examine whether your project is in compliance with the applicable zoning plan for the area where you want to develop or repurpose, and technical standards, which technical standards in construction law in Slovakia are binding. And there are technical standards for many things that, as I'm sure in other jurisdictions, such as, you know, daylight exposure, such as parking spaces, and even technical standards for things such as hotel or accommodation properties have specific technical standards for facilities that they must have. And for instance, if you want to repurpose your property from residential to hotel, for instance, you'd have to comply with specific technical standards to develop facilities in the hotel to meet certain category. And all these I mean, obviously there are legally binding requirements, but they're below the level of law. So all these sub-legal requirements, they do allow some leeway and some interpretation on the part of the construction authority, which is the municipality. And so in conclusion on this specific question, I would say there's a framework to effectuate your change of purpose of your property, but the framework is quite minimalistic, I would say, and there's a fairly large body of sub-legal norms, such as technical standards and zoning plan, which then give the authority, the municipality, a fairly broad degree of discretion to maybe require extra things from the investor, to have them undergo more assessments by various authorities to demonstrate in the proceedings on change of purpose that the new purpose will comply with all the public interest requirements.
Thank you. That's I think a nice wrap up, Bruno. Just maybe more specifically asking about, and also here, one of the pivotal points is the zoning, as you had mentioned. Again, as an individual, can you influence it? Are you entitled to apply for changes? Is there a legal process in which ultimately somebody has, I would say, appeal rights or a certain standing? Or is this more or less just in the free discretion of the authorities how to react with respect of applications or suggestions for change of zoning?
That's a very good question, and yeah, I mean, you really hit the point, Peter, that zoning, like I mentioned in other countries, is really the Achilles heel of our process here, because once it turns out that the zoning plan doesn't allow your type of purpose in the area you want to develop, that can very easily become fatal to your project. The thing is that in principle, the short answer to your question is yes. I mean, there's a process by which an individual can initiate a change in a zoning plan, but the problem is that, like with the general framework of the construction code, the process in the construction code for changes of of zoning plan with respect to an individual motion. It only gives the individual, a company or an individual or an interested party, simply the ability to raise a motion to make the change, but there is no standing, there is no entitlement, and moreover, the way the process of updating zoning plan works is really antiquated and complicated and takes a lot of time. So it's really the municipality that has the authority to change the zoning plan. They have to procure the change through obviously authorized surveyors and professionals. And then there's an element of approval by professional government construction authorities to sort of attest the compliance of the municipal zoning plan with a regional zoning plan and nationwide zoning plan. And after all this is done, it must be also approved by the city council, which adds an element of politics into it and which further complicates the matter. So just to give you a taste of how difficult it is, the current zoning plan of the city of Bratislava, which I'm sure is interesting to a lot of investors, the current zoning plan is from 2007, and I think there have been like 2 or 3 changes since then, because every update is such a huge effort by so many interested parties, and there's so many conflicting interests that factor into the process that really make it, I won't say prohibitive, but it's an achievement for everyone when they manage to make an update to the zoning plan, and the updates to a zoning plan really tend to happen one at a time. So there's a motion to make an update, and the municipality will collect these motions, and some other ideas for changes will probably come top down from the municipality, and then it will take years before they have their update ready from the technical perspective, and then the political element starts, and obviously this happens across different election terms. So all in all, I mean, this is really the weak point of our conversation, in a sense that updates to zoning are very difficult, and they I mean, there doesn't seem to be any sort of light at the end of the tunnel to this until we change the law or change the process.
Zoltan, now the switch to Hungary. Thank you. First of all, Bruno, thank you for this concise, I think, wrap up. I think that was really useful. Zoltan, how is the situation in Hungary? How would you describe the legal framework there?
Yes, thank you, Peter. Well, the situation in Hungary is basically very similar to the situation in the Czech Republic and Slovakia, but there are also some important differences. In Hungary, the function of the building is determined as well in the occupancy permit, and the owner must use the building in compliance with such function. If not, the owner will be fined by the competent authority, just like in the Czech Republic and Slovakia. Now, the good news is that the function of the building can be changed in Hungary as well. And for this, some very general conditions must be complied with. First of all, the new function must be compliant with the nationwide regulations and also with the local zoning regulations. And secondly, the building must be suitable for the new function and must continue to meet the structural and safety requirements. For example, maybe it's not a good idea to turn a residential building into a warehouse if the structure of the building cannot support the heavier weight, but that's just a plain example. And usually when we think about the function change, the most notorious issue is the local zoning regulations, just like in the other countries. In respect to your question in connection with whether individuals can approach the municipality and initiate the change of the local zoning regulations, the situation in Hungary is that yes, they can approach the municipality, but not in an institutionalized form. So they can basically put pressure on the members of the municipality and approach them in non-official ways. So having a decent procedure for this is not available in Hungary. And generally speaking, the applicable framework for the function change is pretty clear, but the construction authorities and the municipalities are local, so their practice may differ a lot. Fortunately, our experience with this is that both the municipalities and the construction authorities tend to be very approachable and cooperative in case clarifications and discussions are necessary with the developer. Just a few words about the procedure. The procedure for most changes in Hungary are unified, so it really doesn't matter what kind of change we would like to achieve. The rules will be the same. There's a big exception, though, which I would like to highlight, because in Hungary we have this so-called plaza stop rule, which basically hinders the opening of commercial or retail areas above 400 square meters. This is an important exception, but it is really just a side note because the relevant permitting rules fall under a totally different legal regime.
I remember when this plaza rule had been enacted, there was quite some, of course, there was a huge discussion. I remember. I could imagine, of course, that nowadays, I mean, also given the shifts that I described in terms of retail, and this is no longer such a, there is probably also not so much demand for projects that would fall under the plaza rule. Would that be correct?
Yes, that's correct. No one is trying to challenge the authority in connection with this, so they are aiming to keep the area below 400 square meters.
But I mean, in terms of demand by investors or developers, would you see that currently? I mean, if the plaza stop weren't there, would you think that there would be more projects?
Yes, absolutely.
Okay.
So
I
usually
think
this is blocking. Yes.
Yeah. That's interesting because I think that sets you apart from other countries, I would say, where probably the demand is mostly saturated, at least by large, in terms of larger retail developments. So that's, I think that's quite remarkable.
Yes, but we also need to add that this is very politicized. So if someone has a good relationship with the government, they will probably have no problem with opening the retail areas above 400 square meters. Which basically means Hungarian investors.
So bottom line is that I mean, just very the summary line is that you think the legal framework of what can and what cannot be done is quite basically straightforward. As regards Hungary, there is no or little gray areas. Would that be correct?
It is correct for the general legal framework, but we also had an important change to the legislation since 1st of March this year, which introduced the obligation to obtain an approval for those function changes that would otherwise not require a building permit prior to the implementation of such change. And the decision in connection with this is with the mayor's office, and every municipality has to develop their own procedural rules, which is being carried out right now. And these procedural rules differ from municipality to municipality. So this makes the picture not that clear anymore.
That's interesting. So you already see problems in this respect, when I understand you correctly.
Yes. These new changes do not facilitate the change of the real estate functions at all, because until 1st of March 2021, you didn't need a prior approval to implement the function change. But now you need it from the mayor's office, and it is again quite politicized. So it's not that easy anymore to change the function of a building.
That's that's I think very important to know. Is there other elements that you would, Zoltan, that you would kind of highlight in terms of specifics of the Hungarian system, things where you would see, besides the ones that you already touched upon, maybe room for improvement, room for changes? Is there anything that you think would be worth mentioning to add in this respect?
Well, procedural deadlines could always be shorter, but beside the two main points, the Plaza Stop Act and these new changes, which was a big step back, I think our system is quite acceptable.
Yeah, but in terms of process, when I kind of read between the lines of what you say, in terms of process, the legislative changes have added to, I would say, also uncertainty in respect of the duration of proceedings, right? That must be a consequence of the unclarity of procedural rules. Would
Yes,
that also
that's
be
right.
true?
Yes,
Yeah.
that's correct. The procedure is longer now.
Yeah. So I mean, just as a kind of a, I would say, as a practical advice, maybe too strongly phrased, but as a practical sideline, when you think of repurposing, let's say, take a random example, in a hotel building in Budapest, want to convert it into apartments, by large, what would you tell a client, how long should he take into account to achieve this in terms of procedurally? Subject to, of course, all the technical questions being clarified, etc. Let's assume that there is no issues in this respect, but and otherwise, I would say rather straightforward thing. How long would you advise somebody to take his or her time for that in the Budapest framework?
Yes, well, if a construction permit is not necessary for the changes, we would say that the change can be implemented within 4 or 6 months. If if a permit is necessary, it would take longer, like 7 to 8 months.
Yeah, thank you. That's interesting. Now, for any of people's listening in or watching, of course, we are prepared to, and our experts are prepared to take questions in the chat function. So take advantage of that when you have something that is on your mind. Of course, each of us will be available also afterwards for more specific or more individual questions, because I'm absolutely aware that this tour horizon doesn't allow us to go into an often required level of details at that point. If I may ask basically all of you something that we see kind of emerging in other legal systems at the moment, and where we have, such as, for instance, in Germany, already a codified legal system in this respect, or where we have in Austria rules and regulations to that extent in our in total 9 different zoning acts. This is contracts between municipalities, authorities, and individuals, allowing individuals for a deviation from the given zoning, an alteration, an amendment of a given zoning under certain conditions and impositions. Mostly, I would say such contracts are geared towards having the private investor invest into the infrastructure, building roads, doing something for social housing, adding social housing flats to his development, or construction of a kindergarten or a school or similar, is under the legal systems, Czech law, Slovak law, Hungarian law. Is this a known concept, such contracts? I would summarize them as urban planning agreements. Is this something that you know, that is this practice somewhere? Is there a legal basis for this somewhere?
Yes, so if I may start in respect of Czech Republic, yes, we have this concept in our law. So it's known to the Czech law when by this public agreement, how we call it, you may replace either the zoning permit or even the building permit. However, I have to say that it is not used so much as it can be. And actually one comment which Zoltan brought me in my mind, I do not know whether in your countries, but for example, in the Czech Republic, currently due to the pandemic, we are also struggling with one like factical issue, and that like officers are not present in their offices, and it's very difficult to reach them. Plus, we are expecting elections in the Czech Republic. So to be honest, I would not expect so much public agreements to be entered within this election period before the new representatives would be in place.
Yes, that's interesting. How about Slovak Republic?
Peter, the short answer to your question is no, we don't have such legal framework. The closest concept to that would be a concession agreement, but that's something else. In theory, it's possible that a public authority with the authority to make decisions in the area of construction enters into agreement where it undertakes to issue certain approvals. But that's for public works in the area of infrastructure mostly. I think the reality of the market though has developed a way for major municipalities to intervene in major developments where, for instance, the investor needs access somehow to municipal land, such as, for instance, in the case of the main railway station in Bratislava, or elsewhere in the major parts of Bratislava that are being developed. In those cases, the municipality does have some leverage, and they would typically make such use or access to land, which is typically required, and in the absence of that, the project becomes prohibitive, and the municipality uses the access to such infrastructure to in exchange for commitments by the investors to make certain investments, to create certain infrastructure, etc. So officially there is no such framework. The reality of the market has developed such frameworks where the municipality has leverage.
Thank you. And in Hungary?
Well, in Hungary, we don't have such framework. So what we see is that if the counterparty is the municipality, for example, if they are the sellers of or the lenders of the property, they are willing to accept as a condition precedent the change in the local zoning requirements. So they undertake to change the rules as we want, and then the contract can close.
Yeah, I think that's, an interesting thing. What we also see is that, of course, in this respect, I think legal systems deviate quite substantially. And I think this is really just probably an example for the fact that in some respects, individuals are still, despite the rule of law that, of course, we have throughout, basically, that there is some areas actually where authorities clearly reserve, especially in the field of real estate development, where they reserve kind of their own free decisions and don't want to be influenced by individuals. And I think that clearly adds complexity to development or to redevelopment or to repurposing, and necessitates in all cases that whoever has a plan, wants to achieve something, etc., doesn't have to care about rules, legal framework, checking of that, but probably, simply speaking, good contact to authorities and creating goodwill on this basis is never a harmful thing. And that is not something that can be substituted with appeals or lawyers fighting for certain things. And I think a sensitive approach in this respect is basically needed throughout. I think we will have to wait and see what the future will bring. To what extent, I think it had been mentioned that currently many owners of real estate that is in trouble with the current use are holding out, just waiting and see how things will develop. That's quite natural, very understandable. I think the picture will change when of course, which is kind of quite visible now with the lifting of our support measures, etc., that we have in governments, that there will be an increase of also, unfortunately, bankruptcies, insolvencies, enforcements by banks, etc., that will, I think, speed up the process. And I think, I mean, this is a very general point. It's always convenient to cling to the past, I would say, for all of us. And all of us would want the things to go back to how we know them, how we experienced them, etc. But in some respects, I think it's time to face the changes that are written on the wall in many respects. And I think there is many reasons to believe that the use of real estate that we currently have will not be the use for the real estate that we will have in future. That has to do with several factors. So I think for some of us who I think that it would be good if things could go back to the old norm, and it's time to face new realities and consider changes in time, I think, because as we all noted, these processes take time, and it's often not possible to foresee how long it takes to repurpose something. Monica, I think we have no questions in the chat function, is that right? So obviously all unasked questions have been answered by our speakers. No, I doubt that this would be the case. But yes, as I had mentioned, I would invite all of you who watch this and who listen to this to follow up with each of us. We're here for this. And the topic is of our interest, so we would be delighted to answer all follow-up questions that you may have. Thank you thanks to the panel that we have, to the expert that took their time to describe the legal situation in their countries. And yes, our next webinar on the topic will be on May 12th. And we will be discussing the situation in Romania and Bulgaria then. So see some of you again then and there. Thank you for participating today and have a good day. Goodbye.
Thank you. Bye.
Thank you. Have a good day. Bye.
Goodbye.
Thank you. Bye-bye.